Hello and welcome to the second part of this module on the statuses that grant legal residence. As we just discussed, being a worker or a self-employed person are the two main statuses that allow mobile EU citizens to be regarded as economically active in the host member state. They are certainly the strongest statuses that allow the easiest access to claiming the right to residence. But what happens when a worker loses their job, called involuntary unemployment, or when a self-employed person is forced to stop their activity, such as during an economic crisis? What happens in the event of temporary inability to work because of an accident or illness, or in the event of maternity? What happens to mobile EU citizens when they retire and want to continue staying in the host member state where they were workers? All these cases are taken into account by EU law in order to guarantee that former workers and former self-employed persons may keep, under certain conditions, their right to reside in the host member state where they performed their economic activity. Let's see what these conditions are in more detail. In order to understand whether or not a worker or a self-employed person can keep their previous status, we must first check the reasons why they stopped being economically active. The reasons that justify a cessation in the activity and at the same time allow someone to keep their previous status are involuntary unemployment, temporary incapacity, vocational training, maternity. Let's look in detail at the conditions attached to keeping the person's previous status when they stop work for these reasons and for how long they can keep their status after they cease the activity. Temporary incapacity is a condition that typically does not allow someone to work. This may be because they are ill or because they had an accident. In this case, the person keeps their worker or self-employed status and the right to reside that goes along with it for the duration of the incapacity. There are no further conditions to be satisfied. Involuntary unemployment is probably the most common reason for interrupting an activity. This typically applies to a worker whose contract ends or who is laid off. But it can also apply to a person who has been self-employed and who finds him or herself obliged to stop working. Here, involuntary means that the activity has ceased because of an absence of work for reasons beyond the control of the person concerned, such as an economic recession. Two different scenarios apply to these people. How long you can keep your previous status essentially depends on how long your previous economic activity lasted. The longer you have worked in the host member state, the longer you can retain worker status or self-employed status. If the person had been employed for more than a year, that person would retain worker status indefinitely. If the person had been employed for less than a year, that person would retain worker status for 6 months. After this 6-month period has expired, the mobile EU citizen has to rely on the conditions for residence applicable to job seekers or self-sufficient persons where possible. In both cases, former workers can only keep worker status if they are registered as job seekers. This requirement is different from the status of job seeker. As we will soon see, job seekers have to demonstrate a genuine chance of finding a job, while being registered as a job seeker only requires registration with a job centre without further conditions. Vocational training is another status that permits workers and self-employed persons to keep their previous status. They keep their previous status for the duration of the training. An important condition is that the training must be related to their previous employment. The Court of Justice of the EU has extended the list of reasons given under the directive that permit workers and self-employed persons to keep their previous status to include maternity. If they take maternity leave, self-employed persons and workers can keep their previous status provided that they go back to work after the birth or that they start looking for a job after their maternity leave. In principle, worker status can be kept for a reasonable time after the birth. Let's see a real case on involuntary unemployment to understand when mobile EU citizens can keep worker status if they lose their job. A Romanian citizen living and working in Germany loses her job after having worked for 10 months. She will initially retain worker status for at least 6 months because she was working for less than a year. During those 6 months, she will not have to prove any further status to be entitled to residence rights. This means that she will be able to continue to stay in Germany for 6 months without any further conditions, other than being registered as a job seeker with the job centre. However, after that date, if she cannot find a new job and therefore be registered as a worker again, and does not fulfill the conditions to be regarded as a job seeker, she will lose her right to reside and her access to welfare assistance. What would have happened if that same Romanian national had lost her job after 13 months of working? She would have retained worker status indefinitely. This is because after someone has worked for more than a year, residence rights are secured for good, provided that the person is registered as a job seeker. EU law refers to involuntary unemployment. This concept might seem only to apply to workers with an employment contract, that is to say, performing an activity as a subordinate. Interpreting it this way excludes self-employed persons from the possibility of keeping their previous status. However, as we said before, it can also be the case that self-employed persons have no other choice than to close their business, as can happen, for example, during an economic crisis. If plumbers or plasterers have no work coming in anymore, they will no longer have money to pay social security contributions or taxes and will probably have to close their business. This is what happened in a real case that came before the Court of Justice of the EU. This allowed the court to declare that involuntary unemployment can also apply to self-employed persons. Mr. Gusa, a Romanian national, entered Ireland in 2007. During the first year of his residence, he was supported by his adult children who also resided there. From 2008 until 2011, he worked as a self-employed plasterer and, on that basis, paid tax and social security contributions in Ireland. He ceased working in 2012, claiming an absence of work caused by the economic downturn, and then registered as a job seeker with the relevant Irish authorities. He had no further income, as his children had left Ireland in the meantime and were no longer supporting him financially. He therefore applied for welfare benefits. The application was refused on the grounds that Mr. Gusa had not demonstrated that he still had a right to reside in Ireland. The case finally went to the Court of Justice of the EU that decided that Mr. Gusa could keep his residence rights and therefore also apply for benefits. The court considered that Mr. Gusa, if registered as a job seeker, could keep self-employed status indefinitely because he had been working for more than a year and his activity stopped because of the absence of work, that is to say, because of a situation that was beyond his control and that corresponded to involuntary unemployment. Besides being a worker or a self-employed person, there is another status that entitles mobile EU citizens to stay for more than 3 months in another member state. This status is being a job seeker. A job seeker is regarded by the EU as an economically active person, like a worker is. However, the conditions for legal residence are harder for job seekers to satisfy than workers. A job seeker could be an EU citizen moving from his or her member state of origin to another member state, but they may also be someone who had been a worker in a particular member state, who then lost worker status and became a job seeker. The period of legal residence is different for job seekers. The conditions to satisfy in order to be able to stay for up to 6 months are not onerous. However, the conditions to satisfy in order to be able to stay beyond 6 months, for those legally residing, are much more difficult to fulfill. Let's see these conditions in more detail. During the first 6 months of residence, job seekers are only required to hold a valid identity card or passport. No further conditions are required. Member states cannot automatically require a job seeker to leave as soon as the 6-month period expires. These conditions only apply to first entrance job seekers, that is to say, to mobile EU citizens who entered a new member state for the first time for the purposes of seeking a job there. A mobile EU citizen already living in that member state, as a former worker or a student for instance, does not have the right to stay for 6 months as a job seeker. After 6 months residence, mobile EU citizens can only remain in the host member state if they can provide evidence that they have a genuine chance of being employed and are actively looking for a job. These requirements are to be satisfied by job seekers after 6 months stay, but also by other mobile EU citizens that were previously living in the member state under another status, such as former students or workers who have lost their job. A typical example is someone who has been working in the host member state for less than a year and then loses their status. This person may stay without conditions for a further 6 months, as we discussed before under the conditions for keeping worker status, but after that, he or she has to satisfy the conditions for being a job seeker. The authorities that verify job seekers' status vary from member state to member state. Whether or not someone has job seeker status may be relevant when they apply to stay after 3 months of residence. When they do that, whether or not they have job seeker status is verified by municipality officials. Whether or not someone has job seeker status may also be relevant when they apply for welfare benefits, such as job seekers allowance. In that case, it is generally benefits assessors that verify whether or not they have job seeker status. As regards the conditions someone has to fulfill in order to be regarded as a job seeker after 6 months of residence, mobile EU citizens are usually required to register as a job seeker with the job centre, this to satisfy the condition that they are actively seeking work. On the other hand, the assessment of whether or not they have a genuine chance of finding a job, a condition for having the right to reside in the host member state, is generally the responsibility of the Immigration Office. We said that the two main conditions people have to fulfill to be regarded as a job seeker after 6 months residence are actively looking for work and having a genuine chance of finding a job. We need to clarify what these conditions mean. The first condition is the easiest one to satisfy and to understand. And what does actively looking for work mean? This essentially means that the person must provide evidence of job seeking. This normally requires first being registered with a job centre. Secondly, any other activities that may prove that the person is actively searching for a job. This may include using the services offered by the job centre, such as following action plans suggested by their job coach, updating their CV, sending job applications, correspondence with employers, doing job interviews, doing training, and submitting proof of job applications. So, what does having a genuine chance of finding a job mean? This is clearly a trickier condition to fulfill. The concept of genuine chance is quite vague and gives a lot of discretion to national authorities when deciding whether or not a person will be able to find a job in the future. National authorities must take into account the personal situation of the person concerned, including any qualifications they have obtained, any professional training they have undertaken, and the duration of the period of their unemployment, in order to assess whether or not they have a genuine chance of finding a job. Simply being registered with the job centre is not sufficient for someone to be regarded as having a genuine chance of finding a job. Let's look at some examples of how the genuine chance requirement is implemented. A person who is still seeking work but who provides evidence of having recently undertaken further training that will guarantee them a position as an apprentice upon completion of the training course must be regarded as having a genuine chance of being employed. On the contrary, an individual who is not registered with a job centre or who systematically refuses to accept any suitable employment they are referred for, or who refuses to participate in training courses or other relevant activities, won't be regarded as having a genuine chance of being employed. A long period of inactivity may also be taken as evidence that a job seeker does not have a genuine chance of being employed. We said earlier that during the first 6 months, job seekers are not required to satisfy any other requirement than holding a valid identity card or passport to be able to stay in the host member state. However, some member states tend to consider that job seekers only have the right to reside without being subject to any conditions or formalities for a period not exceeding 3 months. That, if you remember, corresponds to the maximum period for staying in another member state without further conditions. For instance, in Belgium, job seekers already need to prove registration with the Employment Office and that they have a genuine chance of being employed after 3 months of presence in the country. So far, we have been dealing with the statuses that allow economically active mobile EU citizens to reside legally. That is to say, EU citizens that are regarded as workers, self-employed persons, status retainers, or job seekers in the host member state. Regarding the statuses that allow people to reside legally in the host member state after 3 months' presence in the country, we said that mobile EU citizens may also have the right to reside as self-sufficient persons or as students. These two categories are the statuses that, besides being a family member, allow economically inactive EU citizens to have the right to reside. Both statuses, students and self-sufficient persons, must be able to demonstrate having sufficient resources and sickness insurance. It is therefore essential that we clarify these concepts. Both conditions aim to avoid economically inactive EU migrants becoming a burden on the finances of the host member state. So, what does having sufficient resources mean? Having sufficient resources essentially means having enough money to live in the host member state without having recourse to welfare assistance. But how much money is needed to be regarded as having sufficient resources? EU citizens are generally regarded as having sufficient resources when the level of their resources is higher than the threshold for being entitled to welfare benefits in the host member state. In practice, proof of sufficient resources can be demonstrated in different ways, such as having a credit card or a statement of having funds in a bank, or being entitled to benefits such as pensions or contributory unemployment benefit. The origin of the resources does not matter. They may come, for instance, from previous employment or private savings, do not have to be periodic income, and can be in the form of accumulated capital. The resources may also come from state benefits such as pensions, or from third parties such as family members, from child support paid by a former partner, or from a person who does not have a legal link with the beneficiary. Can welfare benefits be taken into account when assessing sufficient resources? Sufficient resources must be assessed without taking into account welfare benefits granted by the host member state. Money coming from welfare benefits must not be considered, but money coming from other state benefits, such as pensions or contributory unemployment benefit, must be taken into account. Let's look at a case study on the concept of sufficient resources. In Belgium, an amount of €892.70 per month, corresponding to the threshold below which a person may receive welfare benefits, has been regarded as the minimum level of sufficient resources needed for someone to have the right to reside. However, a person with a limited amount of resources, like a €500 disability allowance from another member state and accommodation in the host member state, may also be regarded as having sufficient resources. And what is comprehensive sickness insurance? Besides having sufficient resources, students and self-sufficient persons must also demonstrate having comprehensive sickness insurance. This includes any health insurance, private or public, bought in the host member state or elsewhere, that provides comprehensive coverage and does not create a burden on the public finances of the host member state. The European Health Insurance Card only offers this comprehensive cover during a short stay in the host member state, when the EU citizen concerned does not move their residence to the host member state and has the intention of returning to their home member state, as in the case of university study or posted workers. Pensioners fulfill the condition of having comprehensive sickness insurance cover if the member state that pays their pension also covers health treatment. Let's see a case study on sickness insurance that relates to the time before the UK left the European Union. In the UK, mobile EU citizens could use the National Health Service to receive healthcare for free, but entitlement to use this did not count as having comprehensive sickness insurance. This means that economically inactive mobile EU citizens, who cannot rely on coverage by their home member state, need additional coverage from private insurance to have the right to reside. That's the end of this module. In the next module, we will discuss access to welfare benefits. Thank you for your attention.